Stimson Bullitt Endowed Professor of Environmental Law and Associate Professor of Law, and very recently, to her misfortune, Associate Dean at the University of Washington School of Law, and she is our 12th annual Young Scholar for the Stegner Center. The Young Scholar program was founded in 2005 with the goal of recognizing and establishing a relationship between the Stegner Center and promising young scholars early in their academic careers. Recipients of this honor are selected on the basis of their accomplishments, the quality of their academic work, and their promise in the field of environmental and natural resources law and policy. We've had a very elite group that have gone on to do some amazing things over the years, and we are particularly happy to have the funding of the Cultural Vision Fund, which is the sole donor for the Young Scholar program. So Sanne will be lecturing on the flip side of Michigan versus EPA, the recent Supreme Court decision under the Clean Air Act about regulating toxics from power plants. Professor Knudsen received her BS in Environmental Engineering from Northwestern University, her MS in Environmental Engineering from the University of Michigan, and her JD from the University of Michigan. She does a lot of amazing work on the relationship of science, toxics, and impacts on the environment, including some amazing early articles on the Deepwater Horizon oil spill. And we are happy to have her back because Sanne actually started her law career here at the University of Utah as a visiting assistant professor. When she was here, she taught natural resources law, environmental practice, wildlife law, and worked with our clinical students in environmental law. So again, very happy to welcome Professor Sanne Knudsen to be our 12th annual Young Scholar, and without further ado, I'll turn it over to her.
Thank you, Robin, and thank you to the Stegner Center, to Robin, to Dean Adler, to Jen Nystrom for putting this all together. As Robin said, I began my legal career here at the University of Utah, so go Utes and go Cubs. That's what I was doing last night. I always enjoy the opportunity to return to Salt Lake City and to be among friends and colleagues and former students. So thank you for attending this talk. The title of my talk today is The Flip Side of Michigan versus EPA, Are Cumulative Impacts Centrally Relevant? And before I lay out my thesis, let me remind you, and for those of you who've not studied the case, that the Supreme Court decided the case of Michigan versus EPA in June 2015. And in that case, the court reviewed the EPA's decision to regulate mercury from power plants. Importantly, the Clean Air Act gave the EPA authority to regulate power plant emissions if such regulation was appropriate and necessary. And in deciding whether to regulate, the EPA indeed concluded that it was appropriate and necessary, but based on public health concerns. Okay? The EPA took the position that cost was not relevant as to whether to regulate mercury from power plant emissions, and that cost should be taken into account later when setting the standards. Well, the Supreme Court reviewed the EPA's decision and held that the EPA should have considered cost on the decision of whether to regulate because cost is a centrally relevant factor, the court said, to regulatory decision making. And therefore, failure to consider cost rendered the EPA's decision unreasonable. Okay? Read broadly, the case seemed to create a presumption that reasonable regulation in general necessitates some consideration of cost. For many, Michigan versus EPA and the court's emphasis on cost appeared to be an anti-environmental decision with adverse implications beyond the context of the case itself. For example, Harvard Law Review's case note describing the case asserted that the decision, quote, has the potential to impede agencies pursuing aggressive public health and environmental agendas. For this talk, I'm going to set aside the question of whether Michigan versus EPA has actually elevated the importance of cost in judicial review in the lower courts. That's actually the subject of my CLE at the downtown, for the downtown bar tomorrow. I'm also not going to re-examine here whether or not the court's conclusion as to cost was correct or incorrect. Rather, I'm going to accept the broad principles suggested by the court that there may be factors so fundamental to environmental decision-making that failure to consider those factors renders the decision invalid. Okay? So that gets us to my thesis. So in accepting the logic of Michigan versus EPA, I propose that cost is not the only consideration that is foundational to environmental regulation. Okay? To that end, today I want to explore the flip side of Michigan versus EPA and examine how the logic in that case can just as well support agencies in their public health and environmental protection efforts. In particular, taking Michigan versus EPA as a blueprint, I propose that cumulative impacts, like cost, deserve a systemic and meaningful role in agency decision-making. By cumulative impacts, I mean aggregate harms over time and space, the impacts that occur from multiple actions in combination. These cumulative impacts, I contend, are so centrally relevant, to borrow the language from the court, to environmental and natural resources law that failure to consider those impacts is arbitrary and capricious. So in support of that thesis, my talk will proceed in three parts. First, we're going to examine the reasoning of Michigan versus EPA and see if we can discern a blueprint for when the court might find a factor to be centrally relevant. Second, I'm going to try to convince you that cumulative impacts so permeate the set of concerns embodied by environmental and natural resources law that they too are centrally relevant factors that ought to drive regulatory choices. And then finally, I'll provide some examples of how I think focusing on cumulative impacts through the judicial review framework could influence the implementation of environmental laws and reinforce the public health missions. To get started, let's consider the Supreme Court's reasoning in Michigan versus EPA in a little bit more detail. Recall that the threshold for regulating here is appropriate and necessary, and recall that the EPA decided to look at that threshold through a public health lens. In particular, the EPA found that it was appropriate to regulate mercury emissions because mercury is a hazard to public health, and that U.S. power plants are the largest domestic source of mercury emissions. The EPA also found it appropriate to regulate because it had identified pollution control options that would effectively reduce mercury emissions from power plants. And finally, the EPA found that it was necessary to regulate under Section 112, which is the governing part of the Clean Air Act, because other parts of the Clean Air Act were not adequately addressing the serious public health and environmental hazards from power plant emissions. Again, the EPA did not interpret appropriate and necessary as requiring the consideration of costs. Those considerations would come later in the process and in fact did. Now, appropriate and necessary is an ambiguous phrase. The merits briefs for both the EPA and the industry petitioners acknowledged as much. So does the court. The parties also agreed that Congress was silent as to cost in Section 112 of the Act, which is the governing section. Normally, in the face of statutory ambiguity, agencies receive deference under the Chevron doctrine, so long as the court finds their interpretation reasonable. The theory behind this doctrine is that agencies have been delegated the authority from Congress to fill in policy gaps and, in light of their expertise. Notably, the interpretation offered by the EPA would have made its approach to power plant emissions consistent with the approach that Congress took with respect to other stationary sources, namely to decide whether to regulate based on public health and then set emission standards potentially with cost in mind. So one way the court could have approached and resolved this case would have been through a straightforward traditional application of the Chevron doctrine, whereby the court showed deference to the agency. The agency's approach was reasonable given that Congress itself had followed a similar approach for non-power plants. But that was not the approach taken by the court. The court showed very little inclination to defer to the EPA. And instead of emphasizing ambiguity and deference and expertise, as one might expect, the court focused on the breadth of the term appropriate. It used this breadth of this broad mandate, right, to open the door to relevance as the touchstone test. In particular, the court says, appropriate is the classic broad and all-encompassing term that naturally and traditionally includes consideration of all the relevant factors. The court then goes on to invoke long-standing and settled judicial review frameworks to explain that agency decisions are arbitrary and capricious when the agency fails to consider important aspects of the problem. That much is not new. And then in dealing with the Chevron doctrine, the court explained that an agency decision must of course be reasonable, right? And that a decision cannot be reasonable if the court has failed to consider all the relevant factors. Again, the court is establishing relevance here as the touchstone test. Then the court goes on to explain why cost is a centrally relevant factor, okay? And in doing so, the court explains that appropriate and necessary requires at least some attention to cost, okay? And then appealing to something of a common sense line of argument, the court says one would not, that's not yet. The court says one would not say that it is even rational, never mind appropriate, to impose billions of dollars in economic costs in return for a few dollars in health or environmental benefits. Of course, the court was not speaking to the cost-benefit analysis that had been performed by the EPA there. The court was just speaking in generalities. So here, the court uses language so broad that it appears to be making a statement about regulation and costs in general. And to that end, the court says, consideration of costs reflects the understanding that reasonable regulation ordinarily requires paying attention to the advantages and the disadvantages of agency decisions. The court also took note of the fact that agencies have long treated cost as a centrally relevant factor when deciding whether to regulate. The court does not say it explicitly, but almost surely it has in mind the OIRA regulatory review process, which is the process that requires all agencies engaged in major federal rulemaking to perform cost-benefit analyses before enacting their rules, okay? And I think against that backdrop of the established administrative practice, the court concludes that the congressional silence as to cost in Section 112 cannot reasonably be read as an invitation to ignore cost. Now, as expected, eventually the court does look to the statute for support, okay? But as mentioned, Section 112N is silent as to cost. But the section does require the EPA to undertake a couple of different studies before it decides whether or not regulation is appropriate and necessary. One of those studies, the utility study, does not mention cost, okay? The other study, the Mercury study, directs the EPA to consider health and environmental effects, but it also tells the agency to consider control technologies and the costs of those control technologies. This, the court concluded, evidenced Congress's recognition of cost as a relevant consideration, okay? So there is some tie-in to the statute. Okay, of course, the opinion here is consistent with the statute, but in light of how technical the Clean Air Act is, and in light of the fact that the court had never before required the agency to consider cost when implementing this public health statute, this case actually doesn't turn on a technical reading of the statute in the way that one might otherwise expect. So, where does that leave us in terms of a blueprint? One, I submit that the court accepts a loose statutory connection here, not a highly technical reading of the statute. The court seems to rely more on rational thought as a key driver in elevating the relevance of cost. And the court looks to a strong pattern of agency behavior, right, and systemic behavior to conclude that cost is a centrally relevant factor. Okay. Like I said, to be sure, the idea that agencies must consider all important aspects of a problem is not new or radical to the world of judicial review. The interesting part about Michigan versus EPA, however, is the degree to which the court takes an issue of statutory interpretation and delivers an opinion that does not turn on a technical reading. And I read all of the briefs, and the briefs were very much down in the weeds of the Clean Air Act, and the court very much could have parsed the statute in a technical way. Rather, the court, like I said, works from a general principle that cost is relevant to regulatory decision-making. So, with that blueprint in mind, I'll turn to the second part of my talk, in which I'm going to assert that that same frame, okay, that same frame of looking for factors that are central to the mission of solving environmental problems through regulation might actually lead us to a different conclusion, one where cost isn't the only relevant factor. So the most basic place to begin this line of argument is with the very simple observation that people and land are connected. Our individual actions are connected in time and space. We know that much. Look at this beautiful river basin map that one of my students sent me. It depicts the complex network of rivers and streams in the contiguous United States and reminds us that large regions of our country are hydrologically connected, which of course means that our actions in one place have consequences in another. Consider also that orcas love Idaho. Okay? Orcas depend on salmon. So every summer, Chinook salmon travel 1,000 miles up the Snake River and climb nearly 7,000 feet to reach their spawning grounds in central Idaho. The high elevation there and the persistent snowpack make Idaho a cold water refuge and uniquely buffers it from some of the effects of climate change. I have another student who is doing work at NRDC before coming to law school, and she worked on dam removal efforts on the Snake River to restore the Chinook salmon fishery and support the health of orcas that depend on them. And in talking with her about her work, I was reminded of the connectivity of our actions within the ecosystem. Okay? Consider too that there's BPA in turtles. Okay? So this summer, researchers at the University of Missouri Veterinary School released research showing that BPA, a chemical found in plastics and other consumer products, is not only finding its way into the ecosystem, but it is altering the brain chemistry of turtles in a way that causes the male turtles to take on more feminine characteristics. I won't mention that in this situation it means that the male turtles have a greater capacity for navigating. And finally, I can't come here from Washington State without raising the issue of ocean acidification from carbon emissions, which is an excellent example of how we are connected across air and water, despite the siloing of resources in environmental law. So, from Garrett Hardin's Tragedy of the Commons to Aldo Leopold's call for a land ethic, we know that the consequences of collective actions drive the need for regulatory and a cultural response to environmental problems. And so, not surprisingly, while many of our environmental statutes regulate individual pollutants, individual discharges, or individual species, the ultimate goal is a healthy ambient environment. And by looking to the pattern of goals and mandates within the major body of federal environmental laws, we begin to see that cumulative impacts lie at the heart of the problems that Congress has set out to solve through environmental and natural resources regulation. So let's consider for a moment some of those core goals, purpose statements, or research directives that lie at the beginning of our federal environmental statutes. Take the Clean Water Act, which begins by announcing its objective to restore and maintain the chemical, physical, and biological integrity of the nation's waters. Okay? Congress then declares the national goal of making waters fishable and swimmable by 1983. Okay? Whatever the mechanisms used by the Act to control individual sources of pollution, protecting ambient water quality is one of the undisputable aims of the Act itself. Okay? Consider the Clean Air Act, which starts off a bit more vaguely, calling for a regulatory program that protects public health and welfare. Through the details of the Act, we learned that Congress was mindful of how cumulative impacts lie at the heart of public health. So Section 103D at the very start of the Act directs the EPA to research both short and long-term effects of air pollutants on human health. And in doing so, the EPA is told that risks from both individual air pollutants and combined exposures are relevant. Okay? Section 103E, which addresses ecosystem research, similarly goes on to address long-term ecosystem damages and directs the EPA to develop a research program that quantifies exposures to and effects of multiple environmental stresses. Consider, too, that when Congress adopted the Toxic Substances Control Act, TSCA, in 1976, yes, the same TSCA that was reformed this past summer and which had become known as one of the most broken environmental statutes of the 1970s era, yes, even in adopting that TSCA, Congress understood that cumulative impacts lie at the heart of public health risks. Here we have legislative history. We've got the conference report in supporting the passage of TSCA that expressly acknowledged that, quote, oftentimes an unreasonable risk will be presented because of the interrelationship or cumulative impacts of a number of different substances or mixtures. Similarly, the House report cautions that because of the multiple avenues by which humans and environment are exposed to a substance or mixture, and because substances and mixtures do not occur in the environment in isolation, risks may result from complex interactions or because of cumulative effects. Now, on the natural resources side, we see Congress's concern for cumulative impacts more often manifest in mandates that are aimed at balancing resource use between generations. So we see, for example, the National Forest Management Act declares that the Forest Service is to maintain a natural resource conservation posture that will meet the needs or meet the requirements of our people in perpetuity. So we see that intergenerational goal there of resource management. FLPMA, the Federal Land Policy Management Act, the close cousin of NIFMA, directs the BLM to utilize resources in a combination that will best meet the present and future needs of the American people, and to weigh long-term benefits against short-term benefits when developing land use plans. Similarly, the National Park Service Act and the Wilderness Act, though they have more focused missions of conservation and recreation, have similarly in their goals stated the need for creating spaces for future generations. So I submit that in carrying out these land use planning missions, natural resource managers must necessarily grapple with cumulative impacts of their land use decisions over space and time. Now, those of you who are familiar with the patchwork of environmental laws will rightfully observe that the land use managers are required to take cumulative impacts into account through the mandates of NEPA, the National Environmental Policy Act. I will talk about NEPA in a moment, but for now, I want to make the point that even outside of NEPA, The prescriptions of the individual organic acts, in my mind, necessarily require land managers to adopt a cumulative impacts lens if they're going to properly address intergenerational aspects of resource management. So what's my point in walking through all of this? Well, my point is that read together, these aspirational statements start to look like the implementation of a more generalizable ethos, okay? One that bears a decidedly public health and intergenerational focus on a sustainable and healthy ambient environment. Together, environmental and natural resources law can be appreciated as a collective effort towards a common goal of addressing cumulative impacts over time and space. Now, some might argue that broad statutory aspirations are of limited utility, and one ought to be careful to read too much into them. But the seriousness with which we ought to treat these aspirations is amplified if we consider that the major environmental laws also contain mandates and programs to ensure that the ambient environment is protected. And in making this argument, I'm drawing on a similar observation made by Dean Adler with respect to the Clean Water Act. To that end, in a paper published in the Washington Law Review, Dean Adler argued that the aspirational goals of the Clean Water Act merit particular weight in the implementation of the Act because elsewhere in the Act, Congress matched aspirational goals with specific mandates. Naturally, I agree with Dean Adler's logic. And in fact, I submit that Congress followed a similar pattern on the specific issue of cumulative impacts. So, to that end, the statutory commitments to cumulative impacts is not just a collection of goals, they're goals with backup, okay? I always like to use pictures of nature when delivering lectures. It's actually supposed to lower one's blood pressure. So this is not true. This observation of goals with backup is not true in all cases, right? But I suggest that it's true in enough cases to support a broader observation that environmental and natural resource laws are fundamentally aimed at solving problems of collective action, that is, cumulative impacts. So let's look deeper at the statutes again to see where some of the goals with backup exist. Let's look at the Clean Air Act, or the Clean Water Act again, okay? The Clean Water Act, because of its ultimate goal, is a nation of rivers and lakes that are clean enough to swim in. The Act calls on states to set ambient water quality standards for every water body within the state. And then, in writing individual discharge permits, the regulators are supposed to ensure that the terms of the permit will not cause receiving waters to exceed those ambient water quality standards. Now, because the best laid intentions don't always work, Congress added yet another mechanism by which to address ambient water quality, called the Total Maximum Daily Load, or TMDL program. And under that program, states are required to create a list of all the impaired waters and then develop what are called TMDLs for these impaired waters by determining how much of a given pollutant the receiving water can handle in order to meet the water quality standard. And there's a whole process here by which TMDL development identifies point sources and non-point sources, and at the end of it develops an allocation load by which point sources and point sources together are not supposed to exceed that magical amount that would cause the water quality, the ambient water quality standards, to be violated. Now, while these structural designs have played out differently in practice, there's no doubt that the Clean Water Act's ambient water quality standards and TMDL program are designed to address cumulative impacts. And so while individual discharge permits might lie at the heart of the regulatory focus up until now, the various provisions of the Clean Water Act are surely designed to protect ambient environmental water quality. Similarly, the Clean Air Act. At the heart of the Clean Air Act, the structural heart of the Clean Air Act lie the National Ambient Air Quality Standards. And the basic idea is this: For the most common pollutants, the federal government will set national ambient air quality standards to address public health, and then the states will decide how to control local pollution sources to meet those standards. The NAAQS impact the stringency of the pollution control technology that will be imposed on major stationary sources. I'm oversimplifying, but the point is that in controlling individual sources of air emissions, that is in service of meeting ambient air quality standards. Other provisions within the Clean Air Act also recognize the concern for collective impacts. So for instance, the Good Neighbor provision from Section 110, the Clean Air Act requires states to be mindful of impacts to downwind states. At bottom, my point is this: the mandates of the Clean Air Act reflect a congressional understanding that air resources are connected and that collective actions impact air quality. This all might seem intuitive or obvious, but it's in service of that intuition and that rational thought of that centrally relevant factor, right? There are less prominent examples as well. So the Federal Insecticide, Fungicide, and Rodenticide Act, which is a favorite of my non-environmental law colleagues, or FIFRA, which is our major federal pesticide law, and not usually heralded for its public health focus. Even that was amended in 1996 after the National Academy of Sciences warned that it was important to take into account aggregate harm or aggregate exposure to pesticide pesticide residues on food. Okay, and then of course there's NEPA. Okay, and nowhere, I submit, is the generalizable relevance of cumulative impacts to environmental law more apparent than in NEPA. NEPA is a cross-cutting statute in that it applies to all federal agencies. It requires agencies to consider environmental impacts of their proposed actions. NEPA may be the closest we come to an umbrella environmental statute reflecting a uniform set of concerns, and it shows that cumulative impacts have long been accepted as relevant to agency decision making. So remember that Michigan versus EPA blueprint that we developed earlier? Remember how the systemic consideration of cost in agency decision making seemed to elevate the importance of cost in the court's mind? NEPA plays a similar role for cumulative impacts. Only here we have Congress making clear the relevance of these issues to environmental policy, and we have a long history of agency directives on cumulative impacts. More specifically, NEPA creates the Council on Environmental Quality, or CEQ, and the CEQ develops implementing regulations. Since 1978, the CEQ's implementing regulations have required agencies to consider direct, indirect, and cumulative impacts of their actions. Cumulative impacts are defined as the impacts on the environment which result from the incremental impact of the action when added to other past, present, and future actions. In 1997, then, to encourage more robust cumulative impacts analysis, the CEQ published a handbook. And the handbook doesn't have the force of law, for those of you who are taking Chevron doctrine notes, but it is often referred to as the primary guide for federal agencies in their presentation or preparation of cumulative impacts and cumulative impacts analysis. And in that handbook, the CEQ explains evidence is increasing that the most devastating environmental effects may result not from the direct effects of particular actions, but from the combination of individually minor effects of multiple actions over time. Okay? And lest we question the importance of the CEQ statements in this regard, consider that Congress created the CEQ to implement NEPA and gave the CEQ a seat in the White House. So to that end, Linton Caldwell, one of the foremost scholars on NEPA and a principal architect of the act itself, explains that the CEQ was located in the executive office of the president in order to assist the president in fulfilling his managerial duties vis-a-vis federal agencies. This structural design not only validates the authority of the CEQ, but also underscores Congress's commitment to creating an ethos of environmental review among agencies and regulatory decisions. In fact, the creation of the CEQ alongside NEPA substantially strengthens the comparison between the relevance of cumulative impacts and the relevance of cost in regulatory decision making. To that end, we might think of the CEQ as a counterpart to OIRA, both of which ensure that a consistent set of considerations permeate agency decisions. So, at bottom, whether through individual statutes like the Clean Air Act and Clean Water Act, whether through cross-cutting statutes like NEPA, whether in ad hoc amendments like the Food Quality Protection Act, which amended FIFRA, there is an undeniable pattern within environmental and natural resources laws to consider collective consequences of incremental individual actions. Now, of course, one has to be careful in building general arguments like this one. And I'm not suggesting that every environmental or natural resource statute has an implementing mandate that directly addresses cumulative impacts in the same detailed way as the Clean Water Act or the Clean Air Act or NEPA. And in some cases, like with TSCA, the legislative history is directly concerned with issues of cumulative exposure, but the statutory language simply speaks to risk and not directly to cumulative risk. But for those statutes, one has to start with the first principles to explain why cumulative risk are so central to the problem that Congress set out to solve that they deserve a prominent role in the regulatory decision-making process. In a recent article titled Regulating Cumulative Risk, which is forthcoming in the Minnesota Law Review, I've undertaken that kind of argument with respect to pesticide and chemicals legislation. And in that article, I argue that cumulative exposure lies at the heart of the needs that need to be addressed from a public health perspective, and I look to the risk science literature to explain why such a focus in pesticides and chemicals legislation is both feasible and necessary. And I feel fairly confident that if I can make that argument under TSCA, I can make similar arguments for each of the major federal environmental statutes. And I've already given you some of the outlines of what those arguments might look like. But my goal is not to get bogged down in the details of each statute here today. My goal is to take a step back and make the more general argument that cumulative impacts really lie at the heart of the body of the government's response to environmental and natural resource issues. Okay, it's what we're trying to do. It's what we're trying to do through these various statutes and regulations. It is to find find solutions to the problem of collective consequences. So, just as the Supreme Court recognized in Michigan versus EPA with respect to cost, I submit there's a systemic concern for cumulative impacts that supports elevating it to the stature of being a centrally relevant factor in the judicial review framework, which is to say, we might begin to appreciate that cumulative impacts or cumulative risk is not only permissible under the regulatory frameworks, but an indispensable part of rational decision-making in environmental law. So that brings me to the final part of my talk, which is that even if you accept my argument that addressing cumulative impacts is centrally relevant to environmental law, you might still wonder why it would be productive to tie cumulative impacts directly to the legal frameworks governing judicial review, okay? Especially you might think that in light of what I just said about NEPA being a cross-cutting statute. Well, there are at least 3 reasons why recognizing cumulative impacts as a centrally relevant factor would be a step forward. First, NEPA, though broad, contains certain carve-outs. So it doesn't, for example, apply to the issuance of permits under the Clean Air Act. The judicial review framework under the EPA might provide the broadest and the most systematic point of entry into the regulatory decision-making process. That's point 1. Point 2, NEPA is procedural in nature. So NEPA simply requires agencies to consider cumulative impacts and does not constrain the agency's substantive decision. By tying cumulative impacts to the arbitrary and capricious judicial review framework, agencies would be additionally obligated to justify their decisions in light of cumulative impacts. While the arbitrary and capricious standard is still quite differential, okay, it allows courts to take a hard look at substantive reasoning if they are so inclined. Okay? See, for example, Michigan versus EPA. Third, and perhaps most importantly, recognizing cumulative impacts as a centrally relevant factor sharpens the focus of regulatory decisions. To that end, while many of the environmental laws contain goals or implementing mandates aimed at addressing cumulative impacts, issues of ambient pollution are difficult, and therefore, not surprisingly, many statutes have fallen short in their lofty goals of implementation. So, there is work to do, and refocusing on the core missions of environmental and natural resources law might prove useful. How exactly might it prove useful? Well, let me give you a few examples to close out my talk. Let's start with the Clean Air Act. One of the common areas of criticism that EPA faces as it tries to defend its rules under the Clean Air Act, like the mercury emissions rule, is that one area, is the issue of co-benefits. Okay? Co-benefits is an area that might benefit from the cumulative impacts lens. So co-benefits are incidental reductions in emissions as a byproduct of the main regulatory goal. For example, in reducing mercury emissions from power plants, the control technologies would also reduce particulate matter emissions. So what EPA does is in performing its cost-benefit analysis, it relies on those co-benefits, right, to justify the regulatory costs for the main regulatory rule, okay? Doing that reliance on co-benefits has been a point of contention, okay? So in the Michigan versus EPA case, NYU's Institute for Policy Integrity submitted an amicus brief noting that the EPA had been doing this for a long time, since 1978, and that it was a long accepted economic methodology, okay? The Institute had also submitted more recently comments to the agency arguing in support of this co-benefits approach. And interestingly, the NYU Institute for Policy Integrity emphasizes that the consideration of co-benefits is a long-standing practice, right, and it's consistent with the Clean Air Act amendments and the relevant case law. But not surprisingly, that practice has been criticized by industry and other groups as a means of overinflating the benefits of regulation. So the Federalist Society, for example, has argued really that the EPA just turns to co-benefits because its regulations are becoming more marginal in terms of their direct benefits. So where does my suggestion of a cumulative impacts lens lead us? Well, I suggest that if we accept that reducing cumulative impacts is centrally relevant to the mission of environmental regulation, it becomes easier to see that considering co-benefits in the cost-benefit calculus may be legitimate and even a desirable practice. To that end, if we more readily recall that environmental problems are not easily siloed in time, space, or between individual pollutants, we might more readily accept or even insist upon a cost-benefit analysis that reflects such complexity. As another example, consider cumulative risk assessments and pesticide or toxics regulation. I mentioned earlier that I have a forthcoming article arguing that cumulative exposures lie at the heart of the public health risks from pesticide and chemicals proliferation. So here's a chart. You're not expected to read this, but I want you to appreciate its complexity. Here's a chart that the EPA shows to conceptually show the multiple types of chemical and non-chemical stressors that can operate over multiple pathways to create risk, okay? Despite frameworks like this, the statutory language in even our reformed chemicals and pesticide laws do not directly address cumulative impacts. And to that end, the EPA cautions also that the cumulative risk assessment that it has developed is not a regulatory requirement. Well, I suggest that a more mature lens on cumulative risk might suggest otherwise. Both FIFRA and the newly reformed TSCA direct the EPA to regulate substances that present, quote, an unreasonable risk of injury to the health or the environment. And importantly, in making a finding of unreasonable risk, the EPA is required to, quote, consider all relevant factors. Well, if we adopt a cumulative risk lens to environmental regulation, it becomes quite a bit more obvious that the EPA should be assessing risk from combined exposures as part of its risk assessment. One more example. Let's return to the Clean Water Act and TMDLs. Consider that the Clean Water Act's TMDL program, which is supposed to consider cumulative impacts and serve as a backstop to impaired waters, has held great promise in theory, but has achieved little progress in fact. So as of August 2013, EPA assessed the national water quality and reported that in more than half of the nation's assessed waters do not meet standards for their designated uses such as fishing, swimming, or drinking. Okay? And Professor Oliver Hauck, one of the nation's leading scholars on the TMDL program, has referred to the program as a stepchild program, playing second fiddle to, of course, individual discharge permits. Now, while litigation has at various times in history tried to spur TMDL into action, overall, Professor Hauck explains that the lack of accountability underpinning the allocation process has failed to move TMDLs beyond a number crunching exercise. Okay, so how would a cumulative impacts lens in judicial review help? Well, like I said, ostensibly individual discharge permits should already consider the effect of discharges on water quality, ambient water quality standards. These permits should be written so as not to violate water quality standards, and they should be taking and integrating developed TMDLs into this process. That said, whether permit writers and TMDL developers actually coordinate is unclear. So in June 2015, the EPA Region 9 published a document addressing best practices for coordinating between individual permits and TMDL limits. And while they were careful to state in that document that it wasn't official and didn't rise even to the level of guidance, the whole reason for the document was this statement: many TMDLs are written in ways that make them difficult to implement through permits, and conversely, many NPDES permits contain effluent limitations that do not accurately implement the intent of associated TMDLs. Okay? Recall again that this document doesn't rise to the level of even guidance, right? And that it is termed best practices. Well, I submit that if we take a cumulative impacts lens, okay, we might refocus the efforts by permit writers to actually heed the best practices laid out by Region 9, because not just because they're best practices and that's the way that it should work, but that's how it must work if we are to properly address the centrally relevant missions of cumulative impacts that lie at the heart of the Clean Water Act. So I submit that having a cumulative impacts lens that more broadly permeates judicial review in the way that cost does will shift our focus and shift our demands for the regulatory choices that are made when individual acts are implemented. So let me conclude by saying this. We need to bring cumulative impacts back into focus in our regulatory regimes. And translated to legal terms, this means accepting a wider net, a longer leash, a more mature perception on what are the attenuating benefits and harms of regulatory decisions. This means that when questions arise, like whether co-benefits should be included in cost-benefit analysis, there's an identifiable principle within regulatory decision-making that recognizes the relevance of those cumulative impacts and long-term impacts. It means that when statutes contain regulatory thresholds keyed to public health risks, they're understood to include cumulative risks from combined exposures. Okay? It means that coordinating TMDLs with discharge permits is not just an issue of best practice, but of non-arbitrary decision making. So in sum, I'll conclude by saying this. Cost does not corner the market on relevance. If you believe, as I do, that addressing the consequences of collective action is the ultimate measure of successful regulation, environmental regulation, then our judicial review frameworks ought to recognize cumulative impacts as an indispensable part of agency decision making. Thank you.
All right, we have time for a few questions. There are microphones on either side of the room. If you would use those so that the entire audience can hear and also so that it gets recorded properly, we would appreciate it. Do we have questions for Sanne?
I'll take comments and criticisms too.
So one of the problems that I have discovered in doing cumulative impact analysis is the lack of maybe science that will help support analysis. Are you concerned that maybe that the state of the science will cause too much focus on cumulative effects and stall or make regulations too hard because we don't know, so we just guess?
I'm not concerned about that because right now my concern is actually in refocusing our efforts so that, for example, we're not just looking at costs. So costs and cost-benefit analysis suffers from the same problem, right? It's not that when the court says that costs are a centrally relevant factor, that means that we have ironed out all the details of which costs to include, or that the economic models actually permit us to deal with some of the unquantified benefits. But the court still adopts this lens, and in doing so, it's actually putting a value imprint on the environmental and natural resources implementation of those laws. And so it's not my concern that the cumulative, I realize that cumulative impacts is a difficult task, right? But in some ways, by requiring the agencies to do it as a matter of legitimacy, then creates an incentive to advance the science, to even have the conversations about cumulative impacts being the driving force of what we're trying to accomplish under environmental and natural resources law. So I acknowledge that it's difficult, and I acknowledge that actually that's why we see the pattern in some of these statutes where this desire to address ambient issues of environmental health falls by the wayside, because they are the more difficult problems. But I also think that's part of the reason why we ought to start recognizing it as a important part of the decision-making process, so that we can't just sidestep it because it's difficult.
I work with EPA a lot, so we do cumulative impact analysis a lot. It's just sometimes really hard to.
Absolutely, but on the flip side, within the judicial review frameworks, there's a lot of deference given to agencies when agencies explain, right, the difficulties and the uncertainties in what they're trying to do, right?
Okay.
Hi.
So I have what's probably an admin law nerd question, so I apologize in advance for that, but I'm going to ask it anyway. And I just want to say I really like this idea. I think has a lot of potential and importance, and in some ways maybe even sort of recharacterizing environmental law in really important ways that help us understand how it works going forward. So here's my question. Two parts. In Michigan EPA, do you think, or versus EPA, do you think that the court was talking about cost at step 2 of Chevron, or do you think they were talking about it for arbitrary and capricious purposes? And then secondly, depending on what your answer is to the first part of the question, do you think that matters for how courts might look at these statutes for bringing in cumulative impacts going forward?
So I think that what the court was doing, if you read through, what the court was doing was they're actually applying a Chevron analysis, and they get to step 2 of Chevron, right? But what they're doing, and I think one of the reasons why Michigan versus EPA is an important case as a matter of administrative law is that it's a really good example of the court saying that reasonableness under Chevron doesn't look that much different than the arbitrary and capricious analysis. And so you're going to make sure that the court or that the agency is still looking at the relevant factors. That, of course, seems to tie in well with reasonableness, right? So I think what the court does here is it's actually showing us that step 2 of Chevron is actually not that much different than the arbitrary and capricious analysis.
Okay.
What was the second part of your question?
So how does that go to what courts might do going forward, looking at cumulative impacts as part of their analysis of different environmental law statutes?
Well, I still think what we're going to find is that if Congress has spoken, if the statute is clear, right, you can't bootstrap in cumulative impacts, right? In the same way that Michigan versus EPA doesn't suggest that if Congress is clear about costs, that you bootstrap it in any way because it's rational, right? The point here, and I think it dovetails with what the Michigan versus EPA did, which is in situations where Congress is silent, right, then we need to acknowledge, as the court did with cost, here we'd have to acknowledge that the underlying kind of purposes of these statutes, both reflected in their goals but also in their implementing mandates, is one for addressing cumulative impacts in regulatory decision making, and then it therefore becomes part of that reasonableness of the agency's ultimate regulatory choice.
Thanks.
Yeah.
My question goes to the individual statutes that you're discussing. I totally agree with you. I think the cumulative impact analysis is very necessary in all of the reviews. But given the smokestack nature of the underlying statutes, the specificity that like 110, 110A, 110D, 112, as you were discussing, they're very specific. Do you see those acts being able or nimble enough to withstand this judicial review?
So are you suggesting that because the acts are so specific that it would be easy for a court to sidestep and hold it with respect to any particular provision? Cumulative impacts is not kind of the driving force of that provision?
Because if you try to use that logic, at least as a permit writer, if you try to use another statute to get at the underlying need to address those, you're not usually, those kinds of arguments aren't withheld. They're very specific. You have a very specific statute that you're working under. For example, I think this is Michigan. That statute was very specific. And pulling in some ancillary benefits, I think, was its weak link. So how do you get around that given our statutes? Or are you suggesting we need to look at the underlying statutes?
No, I'm actually not trying to make the argument that we need legislative reform. I'm trying to make an argument that uses the statutes right as they are. And it's not a perfect argument, but I wouldn't take it so far as to think that you could cross over between statutes, right? So I don't think that my argument...
You can't mix 112 and 110.
Well, I think that you could, because I actually think that if you look and see what the court in Michigan versus EPA did, it of course focuses in on Section 112, but its language with respect to cost, right? It accepts I would say, what is a weaker connection to the statute that what I would otherwise expect from a technical and complex statute like the Clean Air Act. And instead, what the court does is it substitutes in this more generalizable, kind of rational, almost gut-level reaction to cost, which I submit comes in part from kind of the OIRA regulatory review process where cost-benefit analysis has become so ingrained in the way that we think of regulatory decision-making as a whole, as a pattern. And what the court does is allows that to lead and carry weight. And so I'm saying if we take that blueprint, okay, and again, I'm not arguing that what the court did here was exactly kind of the right move, but I'm just saying if it can do what it did with respect to cost, I can make the argument with respect to cumulative impacts, because I think we have as strong statutory language, as strong structural designs, and with NEPA, as strong of a cross-cutting kind of generalizable ethos that I think we can make the same arguments with respect to cumulative impacts. Right? I'm not saying that what the court did was without its own problems, but I think that it's not a one-way street if you accept that particular line of reasoning.
Okay, and with that, we are out of time, so let's thank Sanne one more time.
thank you all for coming. I'm going to hang around, so if anyone has any questions, I'm happy to answer them.
And we hope to see you at our next event.
What? You think it's a step one? I don't think it's a step one.